As of early 2026, corporate liability violently shifted from theoretical regulatory warnings into an era of highly punitive, event-driven federal litigation. The catalyst is a deceptive practice known as AI-washing, misrepresenting, exaggerating, or entirely fabricating a company's artificial intelligence capabilities. This deception has triggered a massive wave of securities class actions and multi-agency regulatory enforcement threatening public issuers and private lenders alike. Suddenly, the financial stakes have reached historic milestones, with the median settlement for Securities Act violations spiking to $32.5 million. Emboldened by massive payouts, plaintiffs are deploying rapid response algorithmic market monitoring to expose discrepancies between AI narratives and actual technological reality. The sheer volume of AI-related securities class actions more than doubled recently, and that aggressive momentum shows absolutely no signs of slowing down. The first major typology of this fraud is the human-in-the-loop deception, where companies tout fully autonomous systems that actually rely on human laborers. In one high-profile docket, an enterprise marketed bespoke AI platforms to Silicon Valley, but allegedly delivered work performed by thousands of low-wage offshore manual data entry workers. To compound the alleged fraud, while this company was publicly bragging about massive AI capabilities to investors, they were privately slashing internal research and development spending. The operational reality of the enterprise fractured further when an unannounced mass layoff of over 100 employees triggered a federal labor investigation. This stark contradiction provided plaintiffs with potent circumstantial evidence of fundamental weakness, proving the underlying AI infrastructure was essentially a rudimentary facade. The second major typology is the manufactured partnership, an aggressive fraud scheme where proximity to an AI behemoth is entirely fabricated. In early 2026, a robotics company issued a heavily promoted press release announcing a hands-on commercial collaboration with Microsoft. They explicitly claimed a joint engineering effort to deploy agentic artificial intelligence, an announcement that instantly pumped their stock price by 44%. Crucially, within 24 hours of this explosive valuation surge, the company announced a highly dilutive $38.7 million private placement. But the scheme collapsed overnight. Investigative reporters contacted Microsoft, who unequivocally denied the existence of any commercial or collaborative partnership. Microsoft clarified that the company had merely utilized a basic one-week complementary development sprint available to practically any startup testing Microsoft tools. Following this massive revelation, the company's stock plummeted nearly 30% over the next 2 trading sessions as the fabricated algorithmic validation was exposed. The third insidious form of AI washing is algorithmic masking, where a company misrepresents the origin, stability, and control of their digital architecture. Executives frequently attribute short-term customer acquisition to their own proprietary artificial intelligence when the enterprise is actually at the mercy of third-party advertising platforms. One beauty and wellness disruptor claimed rapid revenue growth was the direct result of a proprietary AI-driven online platform utilizing bespoke data science. In reality, their customer acquisition matrix was heavily dependent on the standard volatile advertising algorithms of entirely separate social media partners. The conflict climaxed during an earnings call when the CEO admitted to a severe dislocation in the account of its largest advertising partner. A simple algorithm change by the partner diverted their advertisements to lower quality auctions, causing customer acquisition costs to spike abnormally. When the CFO announced this algorithmic dependency would cause a massive 30% year-over-year revenue decline, the stock crashed by almost 50% in a single day. Beyond private civil litigation, federal regulatory agencies have formally codified what constitutes actionable AI deception in early 2026. The Securities and Exchange Commission is operating under a strict mandate, viewing AI washing not as a novel technological failure, but as traditional intentional financial fraud. The Department of Justice brought criminal charges against a founder who raised $42 million claiming neural networks fully automated his online transactions. He had secretly utilized a shadow workforce of contractors to process user orders manually, representing the ultimate criminalization of the human-in-the-loop deception. Meanwhile, the Federal Trade Commission established a strict, permanent, dual-prong enforcement template that targets two distinctly different corporate behaviors. The first prong targets the fabrication of deployment, severely penalizing any entity that falsely claims a product uses AI when it inherently relies on manual human operation. The second prong targets performance exaggeration, prohibiting false claims that AI will mathematically maximize revenues without rigorous scientific proof. The FTC finalized a $48.6 million settlement against a corporate entity, proving regulators will fiercely penalize unsubstantiated marketing claims. The surge in litigation is occurring against a backdrop of rapidly shifting judicial standards where the success of these class actions will be determined by new evidentiary thresholds. The most consequential factor for corporate risk managers stems from a landmark ruling that completely shattered long-held corporate assumptions regarding generative AI confidentiality. The judicial concept of AI legal privilege has effectively evaporated, destroying protections for any corporation lacking strictly enforced enterprise-grade AI software environments. A defendant facing severe federal fraud charges utilized a publicly available version of an AI assistant to analyze his potential legal exposure and formulate strategy. He inputted confidential facts and generated 31 reports outlining potential defense arguments, which he then shared with his retained attorneys. His legal team vigorously asserted these files were shielded by the attorney-client privilege, but a federal judge unequivocally rejected these claims. The court ruled that no attorney-client relationship can exist with an AI. An AI is merely a software tool, not a licensed fiduciary. Furthermore, the defendant possessed absolutely no reasonable expectation of privacy because he utilized a public, non-enterprise platform with a permissive privacy policy. The AI platform actively reserved the right to ingest user inputs for model training and explicitly stated it could disclose such data to third parties. This ruling effectively weaponizes shadow IT, meaning if employees utilize public AI tools to draft internal strategy memos, those inputs are fully discoverable. Geopolitical and ethical disputes have also introduced sudden supply chain excommunication risks, proving that reliance on foundational AI vendors carries catastrophic operational danger. The U.S. Department of Defense officially designated a premier frontier AI developer as a formal supply chain risk, a drastic and unprecedented regulatory action. This resulted from a highly publicized standoff where the AI developer refused to waive its ethical safety restrictions to permit the military to utilize its model. The immediate result was an executive directive ordering a 6-month phase-out of the technology across all defense contractors and federal agencies. This demonstrates that a corporation's core technological infrastructure can be rendered legally toxic overnight due to geopolitical disputes between their chosen vendor and the government. Simultaneously, the extraterritorial liability horizon is rapidly crystallizing as the European Union's EUAIAct enters its most critical phased implementation period. Exhaustive compliance, transparency, and conformity assessment obligations for high-risk AI systems become fully and legally applicable by August 2026. These high-risk systems specifically encompass technology used in employment recruiting, biometric identification, critical infrastructure management, and credit scoring. The primary threat to U.S. corporations is the Act's immense extraterritorial reach, where jurisdiction follows the computational output, not the physical infrastructure. a U.S.-based enterprise providing AI-generated outputs or predictive analytics to clients within the European Union, is fully subject to the Act's draconian requirements. Failure to maintain exhaustive technical documentation and enforce continuous human oversight can trigger devastating administrative fines of up to 7% of global annual turnover. This synthesis of aggressive class action tactics, strict federal regulatory templates, and draconian international compliance mandates generates a highly hostile operating environment.
Enterprise risk managers must immediately address escalating directors' and officers' settlement costs, which represent a multi-front assault on the corporate balance sheet. As the frequency of non-accounting, event-driven claims skyrockets, insurance carriers are scrutinizing AI disclosures with unprecedented rigor during underwriting renewals. A failure to demonstrate robust internal controls over AI marketing narratives will result in drastically increased premiums or specific policy exclusions for AI-related fraud claims. Defending a coordinated multi-agency probe exhausts internal legal resources, paralyzes executive leadership, and leads to immediate contract terminations from enterprise clients. To survive this regulatory crossfire, corporations must radically bridge the structural gap between their engineering divisions and their investor relations teams. No public statement regarding AI capability should ever be published without documented verification from the Chief Technology Officer proving the claim's technical validity. Corporations must enact zero-tolerance bring-your-own AI policies with severe employment consequences to prevent compromised legal privilege. All algorithmic deployments must undergo cross-border impact assessments, and vendor supply chains must be actively diversified to insulate against sudden government blacklisting. The unchecked use of shadow AI by employees creates massive hidden enterprise liabilities that plaintiffs' attorneys are eager to exploit in court. Implementing a centralized AI governance committee is no longer just a corporate best practice for multinational enterprises. In the violent transition of the 2026 corporate landscape, strict algorithmic governance is an undeniable existential legal necessity.
Subscribe for more insights on the laws that shape business. The law doesn't wait.